Right. Uh, After the duty of care has been proved, the second part that the plaintiff or the claimant must prove is that there is a breach of duty. Uh, there is a breach of duty. Uh, so, in the case of Bliss and Birmingham, Waterworks Company, the courts Judge Alderson B. Decided that negligence is the omission to do something which a reasonable man, guided upon those considerations which ordinarily regulate the conduct of human affairs, would do, or doing something which is prudent and reasonable man would not do. So, if a duty of care is gauged or is measured by the the neighbor's principle, right? The neighbor principle for breach of duty, right? The measurement is that whether that breach, right? Whether that breach would be true by the opinion of a reasonable man. So it use a reasonable man test in the case of breach of duty. Right? Whether a reasonable man or ordinary man would think, or whether that reasonable man, right, would breach that duty. So that is the test under the breach of duty. So in this case, reasonable man has been described as the man on the omnibus. Means an ordinary man. So omnibus is ordinary lah. Ordinary man who is expected to have any particular skill such as that possessed by a surgeon, a lawyer, an engineer, or doctor, unless he is actually one. Right? Meaning to say, if that's skill, if that skill, for example, by a surgeon, so the surgeon, so what is the measurement for a doctor, for example, is must be measured by the standard of doctor. A lawyer, so the standard of the duty, and when there is a breach, so we have to follow the principle or the SOP as a lawyer. So same goes to engineer and other professions. So like a manufacturer, for example, so of course the manufacturer has their SOP before producing the product. So we look at the same level as a manufacturer, whether to measure whether there is a breach of duty or not. So that is the test lah. So it's case by case. In other words, it's case by case. So if other professionals, so different profession would be gauged by a different measure. Of course lah. Okay. So in terms of that breach, whether there is a breach or not. Like a driver, for example, a driver. So we have to go for standard. What is the standard of reasonable or ordinary driver? Not the F1 driver, the ordinary driver, if there is negligent or not. So we have to follow the SOP according to the case. So if the SOP as a driver, for example, to give a signal if they want to cross, something like that. So whether there is a breach or not, then we look at the knee. So as a driver, you cannot drink and drive. You cannot use your phone while driving. So that is if there is a breach on that, so the the test would be a reasonable man test. A reasonable man test in accordance with the case. We cannot generalize the one case to another. Okay, the third ingredient that the claimant has to prove is that there is a damage. There is a damage. So, and that damage must be caused by the defendants. Defendants, of course, when the defendants breach the duty, caused by the defendants. There must be a causations lah. The causations. Link between the defendant's breach and the damage. It cannot be too remote. It cannot be too remote as a concern of it. For example, if there is an accident, for example, that caused by the driver, you as a what as the witness, for example, to the accident, you feel shocked, and then you suddenly you sue that driver. So that is too remote. So what that is meant by remote, remote consequence. So in other words, the damage must be direct linked to the uh, to the consequence of the breach of the defendant's breach duty. Okay. So that's why in the case of Barnes and Chelsea and Kensington Hospital Management Committee, the court held that the failure of a doctor in examining the disease is not a negligence, since even if the disease had been examined and treated with proper care, the probability was that it would have been impossible to save his life. So whether a particular harm was reasonably possible is a question of fact that depends upon the peculiar facts of each case. So again, it's based on case by case. So we cannot generalize one case to another, right? To determine whether there is a remote consequence or whether the damage is caused by the defendants. Direct damage is caused by the defendants. It depends on the case by case, right? So again, the other principle under the damage causations is we don't state here is a but for test. But for test. But for means it if were not. It if were not. If it were not because the defendant's breach of duty, the damage would not have been existed. Would not have been existed. Meaning to say, in other words, if the defendant doesn't breach the duty of care, right? If the defendant uh, uh, did not breach the duty of care, the incident would not have been happen. So that is the analogy of the but for test. So for example, like in this case, even even the if the doctor actually did not examine the disease, the what you call that, the patient, the patient still cannot be saved. Mean to say, the actually the the damage actually is not caused much by the doctor. Maybe other reason lah. So in terms of contributory negligence, so we're talking about negligence. Sometimes the negligence is caused by, of course, is caused by the defendant, but not. We cannot say that we cannot blame 100%. It is due to the defendant's fault. Uh, in other words, the defendant may contribute only 30% or 50% or 60% or 70% of the, or even 80%, 90% of the damage. In some case, it may be it only the defendant's force will only contribute to 50%. So in awarding the damages, the court would actually quantify, right, based on the fact, with using the just and equitable manners, how much that the plaintiff, the defendants, that contribute the negligence. So uh, let's say the plaintiff sued for 100,000. So when assessing the damages, the court is in the opinion that the damage caused by the defendant is only for, let's say, 50% or 60%. So the defendant would actually pay for the said percentage of the damages. So it's not necessarily 100% caused by the defendant, right? Okay, right. So that is the principle of the negligence. So in any negligent case, involving under the law of tort, so we